Good evening and welcome. I'm Debbie Gross. I want to thank the League of Women Voters for sponsoring this program with us and putting the word out. We have 140 registrants, so we ask you to be patient as we allow people to join us. We are also broadcasting this, I'm sure that's probably the incorrect term, over Facebook Live. So thank you. So we'll just give it one more minute before we actually start. Let's start. As I say, I hate to penalize those who come on time. So thank you all for coming. I'm Debbie Gross. I'm the CEO of Pennsylvanians for Modern Courts. We are a Pennsylvania statewide, nonpartisan, nonprofit organization devoted to educating people about the judiciary and the court system, advocating on behalf of access to justice, modernization of the courts. And we have asked Rob Byer, who is a partner at Duane and a former Commonwealth court judge, to join us to talk about threats to Pennsylvania's judiciary. I wanted to, I'm going to share my screen. Hold on. Show from the beginning. Okay, can everybody see that? For those of you on Zoom, if you have any questions, please put them in the chat. We will try to get to them as we go along. There are a lot of you, so be patient and we will do our best. Again, thank you to the League of Women Voters for helping us with this presentation and bringing the word, spreading the word about this presentation. It's a very important topic. Wanted to give you a little bit of background information about the court system. I don't know how many of you, just some basic background, how many of you hopefully voted this past year in an odd number year in 2021 for the elections for the Pennsylvania judicial candidates. But a little bit about our Pennsylvania court system. We are a pyramid, which our highest court is the Pennsylvania Supreme Court. It was in the news today. I think Rob would be more than happy to tell you about the news, but it rendered a decision. Rob, why don't you address it a little bit?
Well, sure, because it's a decision that was, I know that the League of Women Voters was very much interested in. And this dealt with the 9 appeals that were pending from the Legislative Reapportionment Commission's decision on final maps for the House and Senate districts in Pennsylvania based upon the 2020 census. And in a word, the Pennsylvania Supreme Court, notwithstanding the hotly contested issues, particularly the accusations of extreme partisan gerrymander that were being raised by the House Republican caucus against the commission, the court unanimously, vote of 7-0, affirmed the commission's maps. So we think this was quite a milestone in terms of Pennsylvania redistricting, and the new districts are ones that I think I'm very proud to have played a part in helping to create. And I think they will stand Pennsylvania in good stead as we try to preserve and protect and further our democracy.
Thank you. So the Supreme Court has the final say. Well, I guess there's always a possibility of appeal, but it has the final say in most things related to Pennsylvania law. As you know, the judges elected to, we elect our judges. They are 10-year terms initially, and then it's a retention vote. Yes or no, do we keep this individual as a judge? You'll hear a little bit about some bills in the legislature to possibly change that. The court below the Pennsylvania Supreme Court, we call them the intermediate appellate courts. We have two in Pennsylvania. One is the Commonwealth Court, which Rob was appointed to, and we also have the Superior Court. The Commonwealth Court, Rob, do you want to explain what the Commonwealth Court does?
Commonwealth Court is a court that's unique in the nation, actually. It's mainly an appellate court, but it's also a trial court on certain issues involving the state government. And the thing that the Commonwealth Court has is sort of the touchstone of its jurisdiction is that all of the cases that come before that court involve what you would call public sector law. They do not hear any private disputes. It's always cases involving the relationship between citizens and the government of one sort or another. They don't hear most criminal cases, even though those involve citizens and the government. But apart from criminal cases, the Commonwealth Court is really the court that gets involved in anything involving government activity. So that in a nutshell is what that court does, both as an appellate court and as a trial court.
Great. And so our Superior Court is an intermediate appellate court. All cases that are from the Court of Common Pleas, civil or criminal, have a potential to be appealed to the Superior Court. It's one of the busiest courts in the nation, I will say. Again, the judges are for 10-year terms. We just had elections for Superior and Commonwealth Court judges in November, and the courts below the intermediate appellate courts are the Court of Common Pleas. We have 60 counties in Pennsylvania, and each of those counties has its own court, I'll say, of common pleas. We are a unified judicial system. There should be coordination, and the computer systems and management systems, I'll say, with respect to the criminal courts are much more are on a what's the correct term? Are on a system where everybody can access them. The civil system is not yet there. Is the only way to say it. It takes money, and we're still working on getting money and funding. The entry level courts are the municipal court and the magisterial district courts. In Philadelphia, it's known as a municipal court. And they are, it's a 6-year term. In Philadelphia, judges for the municipal court are attorneys. The magisterial district courts, again, are 6-year terms, but a magisterial district court judge doesn't have to be an attorney, just has to complete a 4-week education program and pass the test. And there is a difference, right, between the Pennsylvania state court judges and a federal judge. Federal court judges, this district court judges, the Circuit Court of Appeals and Supreme Court judges are judges appointed for life. There's no age limit, whereas I would say in the state courts, you have we just recently voted, well, recently, within the past 5 years, I would say, voted on an amendment to extend the age limit for state court judges to 75 years. But in federal court, for the district, circuit, and Supreme Court, they are appointed for life. And the process is in federal court, for district court judge, there is typically a nominating committee that is appointed by the state senators. There's an interviewing process. They make recommendations. There is an FBI investigation, a Justice Department investigation. They make a recommendation to the president. President makes a nomination, and the Senate has a confirmation hearing. It's not the same extensive process, I will say, for appellate court judges and Supreme Court judges with respect to the nominating committee. But right now we are experiencing, in live time, the investigation and questioning of a proposed Supreme Court nominee. I just read a statistic. It was a report that came out from the National Center for State Courts that in 2019, there were 83.2 million new cases filed in state courts. Wow. And there were 376,000 new cases filed in federal courts. So you can see that state courts are, are significantly busier than the federal courts. And they make decisions that impact, your everyday life. Rob, do you have any comments or?
No, it's the federal courts, serve really a different purpose. State courts really are there to decide matters of state and local law. The federal courts are generally deciding disputes over federal law, although they can hear cases involving state law where citizens are from different states. The theory being that it avoids discrimination by state courts in favor of citizens of that state. So that's why there's a provision for what's called diversity of citizenship jurisdiction. But the federal courts, because of the nature of a lot of the disputes they hear, the disputes that are of the highest priority are those that affect everybody in the country. And those are very important cases. Those are the types of cases that generally go to the U.S. Supreme Court. On the state level, the state Supreme Court hears they hear more cases than the U.S. Supreme Court does, but the state Supreme Court cases at most affect people within just a given state. So that's the major difference.
So, we're here to talk about threats to the independence of the judiciary and why is it so important? And it's important because the judiciary is, or should be, a co-equal branch of government, right? We have three branches of government our founders set up. We have a judicial branch, the executive branch, and the legislative branch. And, the judicial branch is to evaluate the laws, protects our rights and freedom by upholding the Constitution and the laws. The executive branch enforces the laws, and the legislative branch makes the laws. It's a process that's been in existence for hundreds of years.
It was very important to our founders that the judiciary be independent of the political branches, that they wanted judges to be free of elective politics at the federal level, which is why Article 3 of the U.S. Constitution was written in the manner it was. And that was to keep judges out of politics, to keep them in a way that they are not subject to political influence. That was the theory. And in the state courts, in many of the states, there were similar concerns. Pennsylvania originally was set up like the federal courts, but that was changed with the advent of what we would call Jacksonian democracy. And the idea came into being that, well, maybe we got to elect these judges, but at the same time, even in states that elect judges, we want to have an independent judiciary so that judges are deciding cases based on the law and the evidence, not based upon who has the political power. So there's almost an inherent contradiction when we're talking about the election process and judges, but I'm getting ahead of myself here.
But you're right. I mean, in Pennsylvania, right, it is, a judge is supposed to be, right, for people to have confidence in the judiciary that it's fair and impartial, right, judges need to remain neutral and impartial. They need to sometimes make decisions that may go against their own personal beliefs or the beliefs in Pennsylvania, right, of a party that they've run through, that they've run on the ticket for. So it is in Pennsylvania, we are, I'd say, I'll put it this way. Judge Brooks Smith, who was the chief judge of the Third Circuit, spoke for Pennsylvanians for Modern Courts, and when he spoke about the importance of the independence of the judiciary, and they really did not like that journalists, because he spoke to journalists, characterized judges by the president who appointed them. Right? He does not like that somebody's referred to as a Trump judge, as a Biden judge. as an Obama judge. He feels very strongly that a judge's duty is to the Constitution, to the rule of law, not to the president who appoints he or she. And here in Pennsylvania, similarly, the judge's duty is to interpret the Constitution, the rule of law, to make decisions fairly and impartially. Judges have to recuse themselves if there's a conflict or an appearance of impropriety. There are rules of judicial conduct where they are not permitted to comment on cases before them. Rob, any discussion or thoughts?
Well, it's very important because, again, we want all citizens to be treated fairly. We don't want people who are part of any kind of a minority to have their rights trampled upon by majority will. And so it's really the job of the federal courts and the state courts as well to protect against the tyranny of the majority. So you don't want to have a situation where judges are predictably deciding cases based upon political pressure or based upon the interests of some constituency. Their loyalty has to be solely to the law, and the idea is to decide cases according to the law, no matter how unpopular or how unpopular something might be. If it's unconstitutional, then the judges have to enforce the Constitution.
There's a quote from Justice Kennedy in a case entitled Texas versus Johnson, which had to do with the constitutionality of a Texas statute that criminalized the burning of the American flag. And Justice Kennedy said, the hard fact is that sometimes we must make decisions we do not like. We make them because they are right in the sense that the law and the Constitution as we see them compel the result. So, I would like to say the judges their loyalty is to the Constitution and the rule of law, not to their own, personal beliefs. In Pennsylvania, the judiciary is set forth in Article 5 of our Constitution. And these are the various articles in the Constitution which give the different branches of government the power. Again, the three branches are to provide a system of checks and balances which offer, protections against concentration of power within one branch. And so what we are seeing recently are proposed amendments to the Constitution, which are threatening the independence of our judiciary. But we need to understand how the Constitution can be amended, right? It is not a process that can occur overnight, but it is a process that can happen I would say in an expedited fashion. The legislature can propose constitutional amendments. They have to be passed by the Senate and the House by a majority vote. The governor has no right to veto a proposed constitutional amendment. After the legislature passes the proposed, it's not really a proposed constitutional amendment. Let me take a step back. It's a proposed constitutional amendment that the Pennsylvanians will get to vote on in a referendum at the ballot. So it's not an automatic. There are a few steps. But after the House and the Senate pass it, then it needs to be published. And what is published is the language and the wording that would be on the ballot. This then has to go through the House and Senate another time. It has to be passed by the House and Senate in 2 consecutive years with the same wording. And then it can be placed on the ballot. So as we will discuss, there are some bills that are more ripe, I'll say, than other bills. But there have been in the past year over 60 proposed constitutional amendments, not all impacting the independence of the judiciary, but that is the way we have been. I'll say Pennsylvania legislature has been legislating. As you, I think the most recent primary ballot had at least 3 constitutional amendment referendum questions. One had to do with the power of the governor, so that the issue is, honestly, people don't understand what these questions on the ballot mean, right? So these are serious threats to, right now, to the independence of the judiciary. So the first bill, I will say, that is most ripe, if that's a way we can use the terminology, is House Bill 38. It is a bill that provides for the districting or gerrymandering, whichever term you'd like to use, for the appellate courts. It is a proposed amendment that elections, so right now we elect our Supreme, Superior, and Commonwealth Court judges across the state. You can, in Pittsburgh, you can vote for all candidates no matter where they reside. This proposed bill would divide our Commonwealth into various districts, so that you in Allegheny County would only be able to vote for the judge who's representing, I'll say, Allegheny County. So the Supreme Court elections will be divided into 7 districts. The Superior Court elections will be divided into 15 districts. The Commonwealth Court will be divided into 9 districts. You know, the status of this bill, so everybody is aware, is that it has passed the House and Senate once. It has been published, and therefore, we are now in the 2nd consecutive term, I will say, of the legislature. So between now and I think it's January 7th, the legislature could pass this bill and it could be placed on the ballot. Rob, do you want to discuss this bill at all?
Yes. This bill grew out of, I think many of us think, a frustration that many members of the Republican Party, particularly in the House of Representatives, had with the Supreme Court's decision in 2018 in the League of Women Voters case dealing with congressional districts. Now, in fairness, Representative Diamond had sponsored this bill before the League of Women Voters decision. But after that decision, that's when it began to get traction. And the idea being, well, you're going to have districts for all these things. We're going to create districts for the courts. And the idea is to, I think behind it is that first, they can, in a way, use this to make a very quick transition of the courts by cutting people's terms short. We have people who are elected to the courts for 10-year terms, but those terms could be brought to an end if all of a sudden we pass this district legislation or this by-district amendment, and it goes into effect immediately. And the bills have been vague on how that would be implemented. It leaves it up to the legislature. But what this will do is balkanize the courts. Right now, the idea is that judges do not have constituencies. This would create constituencies. The idea, I happen to be opposed to judicial elections, so we'll get that right out on the table. And I think I'm preaching to many of you in the same choir. But this bill would make judicial elections worse, because if you have judicial elections on a statewide basis, perhaps local issues do not become as important, and people are voting statewide, and so you take advantage of registration trends for the state as a whole, where, given the way people reside in Pennsylvania, with the overwhelming number of counties being rural and more aligned with the Republican Party, and the Democrats being found mainly in the urban areas, it tends to crack those votes geographically. And so it would make it much easier for Republican candidates to win election potentially. And that's part of the theory underlying this bill. This is not a bipartisan bill. This is sponsored only by Republican members of the General Assembly. And there are a number of other problems with the way this bill is set up. It goes against the theory of judicial elections, where the idea had been proposed for electing judiciaries initially that people ought to have a say in who's making important decisions that affects their lives. So, as Debbie mentioned at the beginning, every voter in Pennsylvania gets to vote on every judge on a state court. But now, under this bill, voters in Pennsylvania will get to vote for exactly one Supreme Court justice, one Commonwealth Court judge, and one Superior Court judge, even though these courts will continue to serve statewide, and you've just diminished everybody's voting power. So it's a bill that is just full of contradictions and full of, I think, bad ideas.
And so what's also interesting, and I haven't discussed this with you, Rob, but we looked at the number of lawyers per county, right? And there are more lawyers per county in the metropolitan areas, right? So we're now choosing, or potentially choosing, lawyers, in counties where there aren't as many lawyers. They don't have as sophisticated a practice. Most of the complex litigation matters actually occur in the metropolitan areas of Allegheny County, Philadelphia County, and Harrisburg and Center County. And so we also have, the concept here that we don't have the lawyers to choose from. I mean, many of the counties in these areas in the center of the state actually have trouble getting judges to run, lawyers to run for judicial positions, and there are openings. So this is a practical, I'll say, factor that hasn't been considered, but it is a reality.
The sponsors of the bill would argue that it's hard for people in these counties to get elected, even when you have good people who want to run. That hasn't been proven to be the case. We've elected people from rural counties to the bench as recently as last year. But with this proposal, it fails to take into account, if the idea is, well, you need to have rural populations represented in their interests. I mean, first of all, the law is the same throughout the state that these courts are applying. It doesn't matter whether you're in Potter County or Allegheny County. When you're talking about issues of state law, it's the same state law. But beyond that, as Representative Emily Kincaid pointed out in her testimony before the House Judiciary Committee, a lot of lawyers in Allegheny County and Philadelphia and other urban areas originally came from rural counties. She points to her own experience in that regard, and there are many others. And so you are still getting people who have some idea of what rural Pennsylvanians think, to the extent that that is relevant. I've never known that to be a relevant consideration, and I served on a statewide court. The other issue presented by this bill is there's nothing set forth in this bill how these changes would occur, right? How are these judicial districts going to be divided? How would the transition occur? Would current judges who are on the court be able to seek retention? So that there's this bill has a lot of questions that it leaves us with as well. And then again, will we be doing this for the Supreme Court first? Will we be doing this, for the Superior Court second? There's just no explanation, but it just shows that this bill was put together in a rapid fashion and brought through the House and Senate in order to, I like to say, keep sort of Damocles over the Supreme Court in its decisions with respect to the redistricting. Didn't work.
Didn't work. Well, so now, so saying that, Rob, okay, we don't know what will happen next, right? Right now, today, the legislature is not in session. The budget is the topic of the day. plus the legislators have to now get names on their petitions and submit them. But there is a possibility that there could be a call to action by the legislature on these bills that threaten the independence of the judiciary. So everybody knows, if that does occur, on PMC's website, as well as the Philadelphia Bar Association and the Pennsylvania Bar Association, there are action items that you can do. You can send in, you can contact your state legislator, send a note, send a postcard, but which is what we've done in the past, and which is what we've been told has been effective. So hopefully we won't have to reinvigorate this, but I guess everybody should just be prepared. The other important thing about this bill was the legislative history. While Rob talked about Representative Kincaid testifying at I think it was at the Judiciary Committee hearing, this bill did not have any kind of public hearing. There was no testimony from any bar association leaders, from any former judges. There was really no discussion. It went through the Judiciary Committee, the House, and the Senate on an expedited basis. So while Rob is correct, Emily Kincaid gave a great speech, as well as Natalie Mihalik, and I think even Todd Stevens, if I recall correctly.
Yes.
Who are both ours and who are both against this bill. There was not any kind of public testimony or hearing.
Right. They were actually not testifying. They were making statements as members of the House of Representatives, as members of the Judiciary Committee. So that is a difference. There were no public hearings on this. There was no public input. And then, many of the ideas in this bill, to the extent somebody thinks that it's hard for people in rural areas to become appointed to the bench or be elected to the bench, even though we've had many, many fine examples of great appellate judges who came from something other than the big cities. A good way to solve that problem is through merit selection, where you take it out of the vagaries of elected politics. And one of the things that you can do through an appointment process is make sure that you have diversity of various sorts, including putting applicants from a smaller county or a more rural county on an even keel in terms of being able to get the attention of the appointing authority. That's much harder in an elected process than in an appointed process. The other thing I'll mention about how this bill was perhaps designed to exert some influence over the Supreme Court in terms of redistricting, I would be remiss if I didn't say that I'm very proud of the way the Pennsylvania Supreme Court handled both the congressional district cases and the case involving the state legislature that was decided today. A lot of people expected this to be done on a party line vote, and it wasn't. The congressional cases, it was 4-3 with a Democrat and 2 Republicans in dissent. Today's decision was unanimous with 5 Democrats and 2 Republicans joining to approve a plan over the opposition, very stringent opposition, strident opposition of the Republican House members. So I'm very proud of the way our Supreme Court stood up to the politics. And I think that's something that that all of us ought to be heard about and speak about in public, because there are a lot of misconceptions out there about how the Supreme Court operates.
And again, right, just because the judge ran on an R ticket or a D ticket doesn't mean that that judge has allegiance to the party. And these are 2 excellent, really supportive examples of the judge's allegiance to the Constitution and the rule of law as opposed to the party. We are one of 7 states that still elect our appellate court judges, but there are even fewer states, I will say, that elect their appellate court judges by district or by region, right? And, it's Illinois and Louisiana electing appellate judges, and Maryland only electing its highest court judges by district. So, it's not something that most states do, and it clearly isn't. It isn't something that we should be doing.
In states that have districts for appellate courts, let's take California, for example, where they have some huge districts. There are more judges, more appellate judges in the first district, which is the San Francisco Bay Area, and the second district, which is Los Angeles County, than in all of Pennsylvania. But these judges, while they are appointed by district in California, they hear cases only within that district. In Pennsylvania, the idea is to create districts, but then the judges would still hear cases statewide. I mean, one could say from the standpoint of docket control, if you had districts, if you divide the state into districts and have judges divided that way, then maybe cases could move through the system faster, although you run the risk of inconsistent decisions. But the way this has been proposed in House Bill 38 makes absolutely no sense to me.
As we said, this is the second legislative year, I will say, that this bill needs to pass, if it's going to pass. So we have till January 7th. So we're hoping that the time will go by, the legislature will not pass it, and this bill then can't be brought forward for 5 years. So at least will be this threat, this most real and most right threat will hopefully go away in the near future. But this year, there have been some other proposed constitutional amendments that have not yet gotten through the House and Senate, but House Bill 2141, which is proposing the elimination of re-election of judges and retention elections. Sorry about that. It's elimination of retention elections, so that the judges would have to run again, right? Just as a reminder, retention elections, right now, a judge runs for retention election, the party is not on the ballot. It's a yes or no, should this judge be retained. We hope that people do their homework and learn about the judge. I can tell you also that, based on our history in Pennsylvania, fewer people vote for the retention election than they do for the election. But as of now, the retention elections are not a partisan process. This bill proposes to require all judges to run for re-election. So again, the judges, while they're sitting judges, would have to be concerned with their decisions that are rendered, would have to be concerned with campaign financing. They'd have to be concerned with contested elections. So this is a very a dangerous threat to the independence of the judiciary.
The last thing you want on the part of a judge is to have to worry about that judge thinking, if he or she makes a decision in a manner that is unpopular with the public, that's going to affect their election, and therefore that will influence the decision. Just imagine in a criminal case, it's usually not very popular to acquit a criminal defendant, or even more importantly, to hold as a matter of law that this defendant cannot be found guilty of this crime. Sometimes you have to do that. Those are not very popular decisions. But if judges are threatened with having to be held accountable to voters every time they do something like that, merely because voters are reacting emotionally rather than on the basis of an understanding of criminal law and concepts, I think we've created a very dangerous world for any of us who might be charged with a crime. To me, it is just untenable to have sitting judges having to run in partisan elections. There are states where it happens. I think it's horrible. The U.S. Supreme Court has commented on that, particularly in the context of death penalty cases. And I'd hate to see Pennsylvania open itself to this. But this is a way of the political powers trying to keep these judges under control and to make sure that they understand that if they decide things that are unpopular to the public or unpopular to a majority political party, that there will be a political price to be paid by that judge. And I think that is very dangerous to our democracy.
So the other practical thing is, right, it is not easy to run for election. It is, in Pennsylvania, you have to go across the state, you have to raise a lot of money. You know, our state Supreme Court elections have now become exceedingly expensive. $6 million was raised in the past, for the past year's seat that was open for the Supreme Court. So it practically speaking, it could discourage and probably would discourage a judge from running for, you know, re-election or even election, because if you're running for 10 years and then you know that you're up for a re-election and you have another contested, you know, election process, it's something that why would somebody want to do it? So we could be discouraging candidates who are qualified. I mean, that's a side issue, I will say. It's really the impact on the threat of the independence of the judiciary that's the most important threat, but it is something that we should keep into consideration as well. And this bill, this 2141 bill, you know, again, is similar to House Bill 38. It arrived in the House Judiciary Committee, I would say, on the eve of Christmas. Really not a lot of notice given. And again, no testimony, no evidence, no input, no public hearings. And then the Judiciary Committee literally had 5 minutes of addressing it. And then there was a vote on party lines. So, you know, there are these concerns that this legislation, proposed legislation, which are constitutional amendments, are really not being fleshed out. They're just being put forth to threaten our judiciary. At the same time as the bill with respect to eliminating retention elections was proposed, there was a bill called House Bill 1880, which was to propose term limits on appellate court judges. The bill actually, as originally proposed, was solely targeted at the Supreme Court to limit it to 2 10-year terms, but in the Judiciary Committee, it was amended to target all the appellate court judicial elections. If you talk to a number of the appellate court judges, you know, current and former, they will tell you that, appellate court judges are generalists. It takes time to gain that knowledge and expertise, and to, again, limit an appellate court judge to 2 10-year terms is another way of threatening the judiciary's independence. It's interesting in that this could be viewed as a step backwards in Pennsylvania, in the sense that before 1968, Supreme Court justices in Pennsylvania were elected for one 21-year term, and they could not be reelected. So in 1968, the Constitution was amended to do a number of things, one of which was to provide that all judges would run in 10-year terms, and it instituted the concept of retention elections for terms after their first elected term. This bill seems to be moving in the direction that Pennsylvania left nearly 60 years ago. So, and then I will say the most recent bill that just came to my attention this morning, and it came to my attention from a call of somebody who's on the House Judiciary Committee, was House Bill 1910. It is proposing an amendment to the Constitution based on the judicial administration. It is proposing to have the legislature be able to pass laws to overrule how the courts operate. again, it's a bill that has not been discussed. There has been no hearing, no public testimony. You know, Rob can point this out. I mean, this is how the federal courts system operates, but the sole intent here was to threaten the judiciary's independence.
It's the motivation behind this bill that bothers me more than what it actually would do. And I'm not sure, and part of it would depend on also how the legislature would act. But as Debbie mentioned, the federal courts actually operate in a manner similar to what House Bill 1910 provides. And Pennsylvania used to operate this way until 1968. One of the other provisions of the 1968 Constitution was Article 5, Section 10, which House Bill 1910 would purport to amend. And in particular, what Article 5, Section 10 provided was that the Supreme Court would have the exclusive power to provide rules of practice and procedure. But then it went on to say that any law, any legislation that was to the contrary of a rule of the Supreme Court would be viewed as suspended. So the court would have the power to suspend laws, and the court even went so far as to say, well, even if we don't have a court rule that contradicts it, if it deals with practice and procedure, that's our exclusive domain, and so we'll suspend it. Part of the controversy on this started when the Supreme Court started taking more expansive definitions of what constituted practice and procedure. So I can remember, I believe it was in 1974, when the Pennsylvania General Assembly passed a sentencing code. And the Supreme Court just simply entered a per curiam order suspending that statute as infringing on its powers under Article 5, Section 10. I'm not sure how you make the case exactly that criminal sentencing is a matter of practice and procedure that can be dealt with through rules. So that was probably one of the more far-reaching examples of that type of power, but the court has used it in other situations as well. Most states do not allow their courts to suspend statutes, and most states allow their legislatures to adopt statutes, even dealing with matters of procedure, and Congress does the same thing. The reason we don't have a chapter of the federal rules of evidence dealing with privilege is because when the US Supreme Court proposed the rules of evidence, Congress took out that chapter. It was controversial, and so Congress eliminated it. So I can't say that House Bill 1910 is completely pernicious in its effect. There are two sides to the debate on this, but on the other hand, it's the motivation behind it that bothers me. And I see that motivation when I look at most of the sponsors of this bill and seeing the other types of bills that these sponsors are proposing. And it's part of, I believe, a concerted effort to try to eliminate or limit judicial independence in Pennsylvania and to make judges subservient to the will of the majority of the legislature.
So the only other topic that's like that is in the control, I will say, of the legislature, which I don't have a slide on, would be the budget, right? So the legislature approves or disapproves the budget for the court system. And we are right now in the budget process. The governor has actually, for the first time in a number of years, proposed an increase to the budget for the court system. And the legislature will be addressing that. So again, we don't know how that will go, but that is a potential threat to our hanging over our court system, not necessarily to the independence of their decisions, but to how they operate.
And that could, at least under the Constitution as it now stands, that would provoke a constitutional crisis that the Supreme Court, as a co-equal branch of government, with the power of judicial review, would probably hold, as it has with various counties, that if the county commissioners, for example, at a time when there was county funding of courts, If the county commissioners fail to provide enough funds, well, the courts would order them to provide those funds. And it's never been done directly at a statewide level, but there are people who are trying to provoke that battle, and I hope we never come to that.
So, as I know some people in the chat have recognized, and Rob has said, and PMC is also in support of a merit selection for judges. There are problems with electing judges, right? It's expensive. It creates concerns of prejudice and conflict. And also Pennsylvanians don't really educate themselves as to the candidates, right? They don't do their homework. In the November election, we had 2 million Pennsylvanians come to the polls to vote. In a presidential election, we had almost 9 million Pennsylvanians come to the polls. So we are electing our judges by a small percent of those in Pennsylvania, and even a smaller percent of those are actually educated about the judges that are running for, office. So there are alternatives. I didn't really go into a lot here. I figured it would be a conversation. I know that Maureen added in the chat, there are so many different ways of selecting judges. And I'm going to put a little plug. PMC has created a judicial selection assessment committee. I would say in the 1990s, PMC put out a report about judicial selection and merit selection. It interviewed a number of stakeholders, over 30 different stakeholders. We've decided that we would bring in, actually part of the committee, have 30 people, diverse across the state, lawyers, non-lawyers, corporate, small business, chambers of commerce, Republicans, Democrats, conservative, liberal, and have a discussion and come to a, hopefully, come to a consensus as to what would be best for Pennsylvania, because we are in a different time right now. But there are different processes to select judges. I know that Rob, had briefly mentioned the California selection. I don't know if you want to discuss that a little further.
Do you want me to talk about that?
Yeah, why not? We can.
California uses an interesting system.
Right.
The governor picks from a list that's provided to him by a commission, and the commission has a composition that includes members of the judiciary. That, for example, if you're talking about appointing a Supreme Court justice, the Chief Justice of California will participate as a member of that commission. If you're talking about appointing a judge of one of the District Court of Appeals, the chief judge, the presiding judge of that district will also be a member of the commission, and so on. And it's a small group. They engage in a very in-depth analysis of qualifications of the candidates, those seeking the position. And they provide the governor with a list of names, and the governor would choose from that list. Senate confirmation is not an issue because that doesn't exist. And then voters can have a say on retention for Supreme Court justices and on the judges of the appellate courts and trial courts in California. They have an interesting system. After they're appointed, after so many years, they have to run in a sort of what I would call a quasi nonpartisan election. What do I mean by that? Well, first of all, they don't run under any political party. Their names will be appearing on a ballot if somebody challenges that judge for re-election. And you have to challenge a specific judge. You can't say, well, there's 3 vacancies or three seats up for election on this particular court, so I'm going to put my name in for one of those seats. No, you have to pick a judge and challenge that judge, which requires then a campaign that's based on saying, well, what's wrong with the incumbent based on that incumbent's record? why would this challenger be a better judge, instead of saying, well, we've got 5 people running for 3 seats, so 3 people are going to win, I might as well take my chances. And then you have campaigns like we do in Pennsylvania, where judges who are serving by appointment are defeated without having one word of criticism about their judicial record. It's an absurd system that we have. I think the California way of doing it makes most sense. And most judges are elected automatically, in the sense that if nobody challenges them, well, then there is no election. They're deemed to be elected. I think that's a great system. And I think that California is not without its problems, but I think on the whole, it's got a fairly well-run judiciary.
I mean, some other states, right, have a nominating committee. But then you have the question as to who comprises that nominating committee, what, and does the nominating committee, how does the nominating committee get names of individuals to run? Should the names of the individuals who are running for the judge for a position be disclosed? Should the nominating committee's processes be disclosed? I mean, there are many different considerations and factors that go into a nominating committee.
I think there are many ways that this can be done. And I think right now we're at a point where maybe it would be a good idea to look at various system designs and come up with what we think is the best system, and then try to gain support for that.
So that's what PMC is attempting to do. So I would like to say stay tuned. We are hoping this process will be about 6 to 8 months. We have actually spoken to representatives in the legislature, both Democrats and Republicans. They are very interested in this process. And we are hoping that we will be able to reach some kind of consensus. Actually, our first meeting for this group will be Friday. So we'll see how it goes. We have involved the Brennan Center, which is a center which if you go on their website, has done a lot of work on judicial elections, on campaign fundraising, on judicial reforms. I know Maureen had put in the chat, some states use a hybrid system for selecting judges, right? Initially, it's an appointment and then the judge is up for election. So there are so many different alternatives that we're going to hopefully bring them forward and have some pretty good discussions about them. I'm just trying to see if there's any more questions in the chat. There's a question in the chat, which is interesting. It says, will we need a constitutional amendment to require our legislature to hold public hearings testimony before proposed amendments get to be voted on? I think we do. Or is it just a rule? I actually don't know the answer to that question. Rob, do you know that answer to that question?
I think there are rules that require that things go, when I say rules in both the state house and state senate, that require that various things go to committees. There are no rules that really, I don't think, dictate in detail how the committee process is to be conducted. A lot of that is at the whim of the committee chair. Right. And maybe we do need some better guidance. Now, there are times, let's take legislation that was dealing with the COVID emergency. There are times when you got to move real fast. And so you don't want to hamstrung legislation and a lot of procedure in a situation where you're dealing with an emergency, but you can provide for that. But maybe I think it is a good idea that we have some better regulation of how legislative committees are to operate in terms of allowing these proposals to be ventilated. I mean, if you watch PCN, as I sometimes do when I have insomnia, and I'm not talking about watching judicial arguments, but talking about watching the legislature in action. It is amazing how little goes on the floor of the House and floor of the Senate. It's discouraging, actually. And you watch some of these committee hearings, and there are some committees that do have testimony, but other committees are just ramming things through. And, what goes on the floor is very little in the way of any real debate. All that's taking place in closed caucuses. And I think that's not the way it was intended to be. And I'd like to see us get back to some basics.
Very nice. Thank you, Rob, very much. I'm going to turn the presentation over to Michelle Null from the League of Women Voters. And again, I want to thank you all for attending, for asking questions in the chat, and we are available if you have any questions or any further questions. Michelle?
Thank you so much for this very informative presentation. I want to encourage everybody as the Director of Advocacy for the League of Women Voters to take action on what we learned tonight. Write letters to the editor, call your legislator to let them know how you feel. Follow the bills on our website under the advocacy tab under Harrisburg Watch, so you are informed about the movement of these bills through the legislature, and educate your friends and families about these threats to the independence of the Pennsylvania judiciary before they might have to vote on them. Because if you don't understand them, as was evidenced by the extension of the age limit a few years ago, people were very confused about that, then people feel like they should just vote yes. And we know that this is really critical to the state of Pennsylvania's future. Thank you so much, Debbie and Rob, for coming tonight and speaking to us and informing us on these threats to the independence of the judiciary in Pennsylvania.
Thank you for having us.